Hello, hello. This is David.
From the lower bar.
Hey, Donna, I'm on the Zoom call here for this seminar. Do you have the PowerPoint? Because it's not giving me this, it's not giving me the share screen capability for some reason. Oh, no, I see it now. Never mind. I see it. I see it.
Okay,
We're
yeah,
good.
because I'm like, I don't have it.
No,
Okay.
the problem is it's recording right now and it shouldn't be. It says it's recording. And we don't want that happening. We want it to stop recording and we want to start the recording around noon. Because
Okay, I'm not sure how to do that. I've never used it before, actually.
well, Cabral Banner is supposedly on here, but she's not. Her
No,
screen's
that's
connected.
logged in as her.
Oh,
She's not in
well,
the office.
so you need to go make me, you need to make me a co-presenter on under the attendees. Why don't you find somebody who knows how to use Zoom and make me a co-presenter so I can control the video, I can control the panel, and I can turn off the camera because right now this is all being recorded. And it's going to make for a lousy video.
Right. I thought that we would edit.
Oh, okay. Well, maybe that's going to happen.
We have an audio video section that edits all of our.
Okay,
videos.
so
They
you,
can take all this
all right,
out.
so you have an edit tool. Okay, all right.
Yes, definitely.
Okay, well, that works for me then. Okay, so then the only question is, if I can see if anybody's on here. Maybe I'm just recording this for posterity because I don't see anybody else on yet, but still got a couple minutes. All right.
Right.
Okay. Shoot. All right. Okay. I'll just start at noon. Thanks.
Okay, sure. All right.
All right. Good afternoon, everybody. We're going to get started in just a couple minutes. Good afternoon, everybody. This is Dave Henry, and we're here today for a CLE seminar entitled "From Business Litigator to Problem Solver: The Habits of Highly Effective Mediation Advocates." I am delighted to have the opportunity to speak to you about this. I've been wanting to present this topic for some time. For those of you who don't know me, I am a 30-plus year business litigator. Gave up litigation in 2019. I've been mediating since 2006, but have been focused on full-time mediation since 2019. And I serve on the Florida Supreme Court ADR Rules and Policy Committee, and I teach mediation advocacy across the country to bar groups and law firms. And I was the head mediation trainer at Marshall Dennehy before I retired. And I think mediation is hugely important. And we're going to cover a lot of terrain in about an hour. I know some of you are here live watching it now, and some of you are going to watch this as a recorded video. And so I'm going to try to make this material as timely and timeless as possible. Mediation is not well understood. It is a dark art, as I like to say. That's because it doesn't come with the attendant rules that we have in other methods of civil litigation. It occurs in a cloistered private setting, so there's no public viewing, there's no record, there's no transcript. And all these things make mediation very different from other things that we do as lawyers, because most of what we do as lawyers is public, necessarily so. And because we don't have recordings, we don't have writings, we don't have transcripts, we don't have memorializations of what takes place in mediation, good mediation advocacy is very hard to learn. I mean, how would you learn something that you can't see, you can't record, you can't watch? Lawyers are pretty much replicators. We learn by watching other people or copy forms, copy interrogatories, copy requests for production, watch a closing argument or an opening statement, and you sort of mimic that behavior, then add your own style. But so much of what we do is some form of replication or duplication or mimicking. And we can't really do that in a mediation unless you're there. So it's very hard to export teachable moments from mediation. So we have to spend a lot of time outside mediation talking about what takes place before we get to mediation, and then what to do inside mediation. And a lot of times mediations go bad before they even start. And that's one of the things I think we'll kind of hark back on and we'll talk about is, what does a good lawyer need to do to create a mediation process that's more likely than not to succeed? And what are those behaviors that tend to lead to impasse or that can promote impasse? So I think being a mediation advocate is really hard because we don't have the same tools available to us to learn how to do it. It's not something we spend a lot of time in law school learning. It doesn't depend on traditional lawyering in the sense of, application of fact to law, dismantling experts, handling electronic discovery. None of those things are of any use really in mediation. And so becoming a mediation advocate is an acquired skill. And it's not one that everybody naturally gravitates toward because it's a different personality set in my mind. It's a different way of approaching a problem. Clients aren't looking for trial lawyers to solve their problems. They're not. We know this because the marketplace tells us that. The marketplace says there's 1% of all filed cases go to trial, 1%. And by the way, that number was true before COVID. So COVID didn't really change the math that much. And no one's predicting a uptick in the number of trials. And there's all sorts of articles on the death of trials and why trials are diminishing, and some members of the bar are bemoaning that fact. But that's the marketplace. The marketplace says trials are too expensive, they take too long, there's too much risk, too much uncertainty, and they don't necessarily offer finality because you can spend all the money on trial and then you might have an appeal. So mediation in the portfolio of investment opportunities to resolve cases is a pretty good pick. I mean, 60, 70, 80% of the cases that come to mediation settle at mediation, and the cost is de minimis compared to trial. The time is de minimis compared to trial. The risk is, there's none. If you don't settle, you don't settle. There's zero risk in mediation. And you have finality. There's no appeals from a mediated settlement agreement. So clients, particularly business clients, corporate clients, purchasers of institutional purchasers of legal services, they're not looking for trial. We know this because CLM, the Claims Litigation Management Institute, did a survey a few years back and said, surveyed claims examiners, in-house counsel, risk managers, how do you pick law firms? How do you pick law firms? And only 1% said trial results. Trial results are not the barometer by which people are picking law firms. They're picking law firms. We say, well, what were the factors? Timely reporting, accurate budgeting. Timely reporting, accurate budgeting. Those are two big factors. That doesn't sound very glamorous, does it? Right? It's not. Clients aren't looking for a business litigator. They're looking for a problem solver. Litigation is just one way of resolving the problem, but it's not very efficient. It's hugely expensive. It carries a lot of risk. So you need to have other tools. And so I don't think it's enough to say I'm a great trial lawyer. I don't really care if you're a great trial lawyer because you're only going to use that in 1% of the cases. What I would be more impressed with if I was hiring lawyers and law firms, say, how good are you at settling cases? How fast can you get this case resolved? Can you get me a good deal, or can you get me out of this for cheap? Those are the numbers that the clients have. They know how long the file is open. They know how much they spent in defense. They know how much they spent in indemnity. They know how much time it took you to get to summary judgment, or how much time it took you to get to mediation. They know what your settlement rate is. That's the data that they have. So that's the data that they're going to use. They don't have data on trials. You don't have enough trials to compare this firm against that firm, and you don't have enough data to get a statistically accurate, statistically rational sample size from which you can draw legitimate conclusions about the quality of your representation. But you can't measure that. You can't compare 10 trials against 10 trials in the same venue, because juries are different, facts are different. So that's the big picture. So the big picture is trials are not the barometer by which clients pick lawyers. Mediation is a hugely valuable skill set and tool. It's here to stay. It's a growth stock. It's not in the portfolio of investments, trials only occur in 1% of the time. So that's like the stock or the mutual fund that nobody buys. Well, why is that? Because it's high risk and it carries a big load. So the fees are high. It's a mutual fund you don't want. So you start thinking in those terms. Then once you start thinking in those terms, you sort of philosophically get your head around the idea that I'm not a trial lawyer, really. I'm a problem solver. Trial's one way I can do it. I can do it with mediation. I could send you to an NDR. We'll talk about that if we have time. So I've got different ways of solving your problem. Mostly what they want is a deal. So the frequency of trials is not going up. This is sort of the big picture problem. They're not going up. The frequency's down. It's going to stay down. And clients don't have an appetite for trial anyway. So why are we focusing all this time on 1%, this 1% thing called trial? People go to trial boot camps. We don't have mediation boot camp. Isn't that a failing? Isn't that an outrageous failing? Think about it. That's an outrageous failing. We have tens of thousands of cases going to mediation every year. We don't have mediation boot camp, but we have a 1% phenomenon called trial, and we'll spend thousands of dollars to go to trial boot camp. See, the incentives are all wrong. There's a problem here. That we kind of got to get our head around. And that is, we need to be really good at the art of mediation. And you can be. It's a learned thing. And we didn't learn it in law school. If we learned how to be a good mediation advocate, it's probably from watching somebody more senior to us, to sort of mimicking or patterning ourselves after that behavior. But sometimes those behaviors aren't very good. Sometimes people we learn under aren't necessarily very good mediation advocates. Part of the problem is the court system. When they first started making mediation mandatory, they said, and they still do this in their trial orders, they say you have to have the attendance of lead trial counsel. Well, that was put in the old orders back in the 1980s and 90s, and it continues. And the reason they did that back in the day was because they wanted it to be taken seriously by the trial bar, right? Well, fast forward 30 or 40 years, everybody takes mediation seriously. Now, we don't really have that problem, but the orders still say lead trial counsel. Well, sometimes lead trial counsel isn't the best person to be at the mediation table. I've had some law partners who were great trial lawyers. They couldn't settle a case. They didn't like going to mediation. They hated it. They weren't deal makers. It wasn't their thing. They were battalion commanders. They get the people to the front and they start shooting. They're not peacemakers. So you got to think real carefully about, am I a peacemaker? Can I be a good, effective peacemaker? And that's what your client's looking for. Yeah, you need to be able to try a case, but they also want you to be a peacemaker. And some large clients now are separating those two things. And some clients are hiring settlement counsel to kind of come in, set up the mediation, conduct the mediation. They leave a defense counsel in place or their trial counsel in place, but they bring in somebody else to help make the deal. And some clients feel that's useful because it takes away the responsibility of settling. It sort of creates the good cop, bad cop scenario. It lets the trial lawyer sort of stay in his or her own mode. I did that for a major carrier and flew around the country and was settlement counsel, and it seemed to be pretty effective because I didn't have to worry about going forward. I was just there for the mediation, and if it didn't settle, then the trial lawyer was back in play. So be mindful of that. You don't necessarily have to be both. Maybe you're just going to be good at settling cases, and that's fine because 95% of the cases that we have are going to go to mediation. So being a good settlement advocate is really important. Let's talk about a couple other big swing thoughts. Unexamined habit and ritual delay. This is a big theme for me. Oh, by the way, if you want to read more about all these different things, I have a bevy of articles on my website you can read. They're little short, they're called mediation minutes, so you read them in a minute or less. And we talk a whole bunch about a number of different topics like attendance and some of the things we're going to talk about here today in more detail, and sanctions and how to do an effective opening and things of that nature. But one of the things I always like to talk about is delay in setting mediation. We don't make early mediation the norm. Some courts are moving in that direction. We're starting to see some movement that way, but most mediations are late. And the reason why they're late, and I know this because I studied it, is because when mediation became a thing back in the mid 1980s, after the passage of the Mediation Confidentiality and Privilege Act in Florida, courts started putting in mediation deadlines. Okay, made sense. And so when they entered their case management or trial orders back in the 80s, they didn't make mediation the first order of business. You say, why? Because early on, when mediation first started in the 80s, it was viewed with a little bit of skepticism. There was a little bit of that sort of knee-jerk reaction. What is this? This is going to take money away from me. I don't know if this is any good. What is this crazy stuff called mediation? And so there was this sort of natural, grousing and skepticism by the trial bars. Not all of it, but some members of the trial bar. And so to sort of placate the early objectors and sort of diffuse some of the anticipated backlash, the courts put the mediation deadline at the end of the case. I mean, imagine if they put mediation at the beginning of the case, it would have caused more of an uproar and a stink. So the courts were smart. So putting the mediation deadline at the end of the discovery period was a psychological ploy to deflect early objectors. Well, nowadays, we don't have those sort of objections to mediation. We're a much more highly evolved mediation culture than we were 40 years ago or 35 years ago when they passed the Mediation Confidentiality and Privilege Act. So, but unfortunately, the courts haven't changed their orders very much. The mediation deadline's still at the end of the discovery period sometimes, or very close to the end of the discovery period. And that's a critical mistake because you don't need a ton of information to mediate a case. You need a lot of information to try a case, but you don't need a ton of formal discovery to mediate a case. You can mediate a case based on a pamphlet of information. I know because I've done it. Lots of people have done it. Okay. But the courts won't push the mediate deadlines forward, and there's no good reason not to. It's just unexamined habit, ritual, custom. And a lot of what we do in mediation is that. It's unexamined habit and ritual. And I really don't like unexamined habit and ritual. I don't find it to be, I look for things that optimize the mediation process, optimize the opportunity to settle the case, and things that detract from my ability to settle the case, detract from the mediation process, or make the likelihood of impasse greater. If you put the mediation deadline at the end of the case, what's going to happen? You're going to have you're going to have bigger sunk costs, harder to get those cases resolved. You're going to have potentially more litigation toxicity. The parties will have become more polarized, more upset with each other because of the vagaries of the litigation process don't tend to generate warm feelings, right? So you got all the sort of, litany of abuses that have been inflicted upon each other during the litigation process, and then you come and try to settle the case. Much better to have a mediation early in the life of the case and then a second mediation later in the life of the case, because litigation objectives can change. Clients can get litigation fatigue. The case can shift in a way you didn't anticipate. Your client might run out of money, run out of desire. Maybe there's market forces that no longer make it necessary to prosecute that trademark case. Maybe there's reasons why we don't need to preserve that real estate deal anymore. A whole host of things can happen that changes somebody's willingness and desire to litigate. And having the second mediation is a great get out of jail free card, because of course you don't want to ask for a second mediation at the end of the case because that shows weakness. But if you plan for two mediations at the beginning of the case, then it's sort of genius and simple and it's easy. And at the end of my career, I figured this out, and I said, well, every time I got into a case, we had a Rule 26 conference or whatever it was, I'd say, let's plan two mediations. Let's do one within 90 to 120 days and give our clients a chance to get out of this thing early. And let's set another one later in the discovery period after we've taken some discovery. So we have a second mediation. And every time I suggested it, I was mostly on the defense side, but every time I suggested it, the plaintiff side said, that's a great idea. Yeah, it is. Why wouldn't you give your client a second opportunity at mediation? Right? Why wouldn't we do that? I don't know. There's no good reason not to. What client's going to fuss at you for giving them a second opportunity to settle the case at a mediation? Right. So that's an example of unexamined habit and ritual. We have this sort of one and done view of well, we did our mediation, we checked the box, okay, we're done. Why don't we have 6 mediations? Why doesn't the court make you go to mediation every 6 weeks? You say, well, that's silly. No, it's not. It's not, because you're going to settle the case anyway. We know in the overwhelming majority of times, you're going to settle the case. You might settle it after summary judgment, before summary judgment, but you're going to settle the case most of the time. So pretending like you're going to trial and spending all this money doesn't necessarily work to the client's advantage. So looking for the optimum time where you have enough information to intelligently assess risk, but not so much time and money invested that the case is upside down, which happens a lot in business litigation, particularly in modest stakes disputes where the amount of controversy is under a couple $100,000. You've got something to argue about, but not for very long. So the other reason mediations are delayed is because sort of this desire for perfect information. Lawyers are hesitant to give advice before they know everything. Well, guess what? All decisions in life are made with imperfect information, and settling a case is no different. The problem is the cost and time and expense associated with getting the quote unquote perfect information is cost prohibitive, and getting a lot of information doesn't really change the handicapping. You can handicap a case pretty quickly if you're an experienced lawyer. You can handicap the case pretty quickly without a lot of extensive discovery. So I'm kind of a big believer in early mediation. A couple things you need to do ahead of time. I created a list, a checklist that I like to use. I'm a big believer in checklists because mediations don't have any rules. They don't really, there's no prep manual that comes with a mediation order. So I've sort of created my own checklist. You can get it on my website, or you can email me in case it's down or something like that. You can email me at dhenry@henryadr.com. Some of you may be viewing this video months or years down the road, and so hopefully that website will still be up. But email me at dhenry@henryadr.com, and you'll get a checklist of things to do. It's a very simple, easy way of sort of thinking about all the things we need to do in advance of mediation. Some of them seem kind of obvious, but sometimes the obvious things get overlooked. I'll give you a simple example. Just the other day, we had a mediation kind of dust up at the very beginning because somebody had prepared to do an opening, and the other side said, I don't want to do an opening, but they hadn't told the other side. And of course, the custom and practice in Florida is normally we do an opening. We do a joint opening. Everybody kind of assumes that. Interestingly, though, if you go out of state, the assumption is just the opposite. I've been in jurisdictions where they don't do mediation opening statements. As a matter of course, they go right into caucus, and that can be upsetting too, because you need to know what the ground rules are, right? So why don't you have a conversation ahead of time with the opposing counsel and say, are we doing opening? Yeah, okay. And you say, well, I don't need to make the call because we're always doing open. Not always. So that's one of the things you put in the checklist. Call the other side. Who are they bringing? Are we doing an opening? Fine. How long do you think it's going to take? Okay, fine. We're sort of a like mind as what this is going to look like. That's a good thing, as opposed to having to kind of blow up at 9 o'clock on Monday morning. Or the other day I had one where somebody came and someone didn't want that person in the room. And we had a whole conversation about whether this person can be at the mediation or not, or should they be outside, and how are we going to deal with that? The rule is very simple, by the way. If you want to bring somebody, you can bring anybody you want to. Some people think that it's limited to parties. That's not the rule. It's never been the rule. It's never been the law. That's one of those myths of mediation. Oh, only the attorneys and the parties can be there. No. The Mediation Confidentiality and Privilege Act speaks to participants. You can bring your brother, your sister, your mom, your dad, your pastor. I had a pastor one time come to mediation. Right. If you need somebody there to help you make decisions, that's fine. If the other side doesn't like it, the remedy is not, I don't decide that. I don't make a decision about who could be there, because mediators don't exert power and they don't make decisions. So if there's a dispute about whether somebody should be there or not, you either got to resolve it amongst yourselves, or the person objecting to the participant has to file a motion with the court saying, hey, I don't want this person here, and you've got to have a pretty good reason. And being a non-party is not a good reason, because non-party status is not a reason for objection, if you know the law and you know the rules. Okay. Attendance by Zoom, of course, requires attention to detail, and I have an article on that too. I spend more time in the article talking about attendance by Zoom, the importance of lighting, the importance of quality audio. These sorts of things can hamper your cause. Most jurisdictions now are requiring that your Zoom camera be on at least during the opening. If I can see you, but you can't see me, or vice versa, there's an informational advantage. I should be able to see you. The other side should be able to see you. Mediator has an obligation to make sure that the mediation is conducted in an even and fair-handed way. And if your camera is off, but their camera is on, that's not fair and balanced, and that's not appropriate. So mediation ethics rules would suggest that I tell you to put your camera on, but the courts are sort of doing me a favor by saying, no, the rules require that appearance means I can see you. So audio participation alone is not sufficient. Okay, So you got your checklist, you're figuring out who you're bringing, you've talked to your client. Here's the thing in business litigation I got to mention to you because it bit me a couple of times, and I didn't when I was younger. The person that you're reporting to for litigation purposes is not necessarily a true voice of litigation. They may be the litigation manager. They may be I said true voice of litigation. I mean, true voice of the company. They may be a litigation manager, in-house counsel, person you report to, but they don't necessarily have the pulse of the company in terms of what the company's objectives really are. And it's really important as you get closer to mediation that you get the true voice of the company. And you ask whoever you're reporting to, who do we need to bring into the loop here? Here's what's on the line. We're talking about the life and death of the company, or this product line, or this deal. We're going to have this kind of exposure, or we're looking for this kind of payout. Who really needs to be involved in this decision-making process that maybe wasn't involved in the day-to-day minutia of the litigation? And you got to have that conversation and get those key decision makers in play at the mediation. There's nothing a mediator will tell you. Every mediator will tell you nothing more detrimental to the mediation process than not having key decision makers. It's like having your star on the bench. You're not likely to get a good result. So it's really important. We want to get a position statement that goes out 14 days or so prior to the 14, 15, 20 days. Time frame is kind of arbitrary, but the concept is you want to get a position statement out to the other side, laying out how you see the case, what the issues are, et cetera. Most people will send me a mediation statement, or they'll call me on the phone, but they won't share anything with the other side. And that's a missed opportunity. That, again, is one of those unexamined habits, rituals, customs. The court orders say, send a position statement to the mediator, but they don't say, send a position statement to the other side. Why wouldn't you want to avail yourself of the opportunity to communicate directly with the other side? I mean, think about it. You get to write a letter to the defendant or to the plaintiff, and for their eyes to read. You don't get the opportunity to speak to them that way in the litigation process. So you can write directly to the plaintiff and say, madam or sir, here's the issues that I see. Here's some of the challenges with your case. When I drafted mediation statements, they weren't for the mediator. They were for the other side, and not the other side's lawyer, the actual party. I try to put myself in the head of the other side. I go, what does that guy or what does that lady need to hear? What can I tell them that would influence them to want to make a deal with me? I was usually on the defense side. What can I tell them that would make them want to make a deal with me? And my mediation statements were pleasant. They weren't hostile. They weren't biting. They weren't aggressive. Because if you're a defendant, think about it, if you're a defendant, you want them to take your money. I can never, when I used to teach these young associates when I was at my old firm, I used to tell them the same thing. And it's like they look at me like, a dog that moved their food bowl for a second. Your job as a defendant is to get the other side to take your money. And it's never going to be all the money that they want. Your job is to get them to take your money. So why would you be snarky? Why would you be mean-spirited? Why would you be abrasive and arrogant? And well, some of you can't help it, I guess, but right? I mean, you want them to take your money. And if you're on the plaintiff side, you want them to give you all the money they can possibly give you and then some more. So why are you upsetting the guy with the checkbook by saying he's in bad faith, or telling them that they're liars and malingers, or telling them that they're a fraud? They know they're a fraud. They know they're a fraud. You don't have to remind them in the opening session. You got to incentivize people to want to make a deal with you. That's your job, not to make them upset and angry and to pull them off the ceiling. Consider an apology if you're a defendant. Apologies are underutilized. There's all sorts of psychosocial data on effective use of apologies. Everybody knows they work. Nobody wants to do them. Or if they do one, they do a half-hearted one from the lawyer. Don't do an apology from the lawyer. That's a person paid to say those words. If you're going to do an apology the right way, you got to have the client say it. You got to script it. You got to rehearse it, just like you're putting on a performance. It's a play. You got to put on a performance, and you got to deliver the apology with some authenticity and earnestness, and that will carry some weight in the other room. It helps. I can't tell you how many times as a mediator I've had a plaintiff tell me in the opening session, in the first private caucus, after the opening session, they say, God, I wish I would have liked an apology. I sure would like that apology. Right. That's what now, of course, they want money too, but the apology sets the right moral tone, acknowledging responsibility. See, there's not going to be a trial. In mediation, there's not going to be a trial. There's not going to be a public presentation. That's why opening is real important for the plaintiff too. They want to be heard. They want their lawyer to tell their story, and you need to listen to it. That's why it's so important to have the opening session and let the plaintiff hear it. Let the plaintiff's attorney say their thing, make the presentation, be receptive to it. The plaintiff themselves wants their lawyer to be their champion, to be their advocate, because they're not going to get to trial. They're not going to go to trial. So when are they going to get to air their story? At mediation. So you got to give them the vehicle for doing that. See, once you start thinking like a mediation advocate and not a trial lawyer, everything sort of changes because it's an ontologically different way of being. It's an ontologically different way of being and problem solving, because you've got to make a deal with your adversary. In litigation, you're not making a deal with your adversary. You're putting on facts and evidence and law in a positional debate to be decided by 6 people who know nothing about the subject matter. It's a very different kind of thing you're doing there than trying to make a deal with your enemy. So there's some things you need to do to make sure mediation is successful and productive. And those things sometimes are a little counterintuitive. All right. 3 ways to reach impasse in multi-party litigation. So you got multiple defendants, construction case, med mal, premises liability, whatever it might be, some kind of fiduciary liability claim, whatever it might be. 3 ways to reach impasse. Do not engage in pre-mediation discussions with the co-defendants and disregard the need for consensus among the defendants. In other words, be in your own little silo before mediation, no intra-defendant communication whatsoever. That's a good way to generate impasse. When I used to do aviation work or construction work, we'd have multiple defendants, nobody talked to each other. We get into mediation, the first 3 hours, we were arguing amongst ourselves about what the proportional share should be, and the mediator couldn't get an offer out the door because the defendants were all bickering about what the proportional shares would be. Well, those are conversations that probably should have taken place days and weeks ahead of time to figure out who was in for what. You know, Zurich, CNA, whoever's involved, or the parties. What's the proportional share between the carriers? And the carriers don't have their act together, and we can't even get an offer out of the defendant. So the plaintiff's sitting in the other room till noon waiting for an offer, waiting for a first offer, which we know is not even going to be accepted because no one talked to each other. And why does anybody talk to each other? Unexamined habit and ritual. When I was in defense practice, how many phone calls did I get before mediation from other defense attorneys? And I did construction, I did aviation. There was always other parties. Now you might say, well, Henry, there's a reason I didn't call you, because no one wants to talk to you. Could be. But you think there's somebody I didn't upset or annoy who would have said before the mediation, hey, let's call the other defendants and see what they think, you know, this case is worth, what the shares are, what's it going to look like in the defense room. Nobody made those calls. Nobody made those phone calls because there isn't any order. There isn't any rule. There isn't any checklist. It's on my checklist. It's on my checklist. So 30 days before mediation or thereabouts, depending on what kind of case I have, I call the other co-defendants and I say, hey, we got a mediation coming up. What do you guys think this case is worth globally? Well, okay. Do we share the same views? Because if your view of the case and my view of the case are wildly different, we're going to have a big problem in mediation. If I think we need to come up with $1 million and you only think it's $500,000, I kind of want to know why you think that. And do I believe you, or do I think you're just kind of clueless? So I got to assess, because if I'm a defendant, I'm trying to settle a case, I need cooperation from my co-defendants. So in a multi-party case, the work that needs to get done is much more difficult, because you not only got to convince the plaintiff to take your number, right? There's a number the plaintiff will take. That's almost not even the problem. The problem is getting the other defendants on the same page, understanding their exposure, their liability, and getting them to cooperate in the form of economic contribution. That's a much bigger challenge, because when you add another defendant, you're not just adding one other lawyer. You're adding a lawyer, a client, maybe a carrier, maybe an in-house counsel, some other decision makers, right? You might have, so it becomes like a 3, 6, 9, 12 problem in terms of the number of bodies that got to be on the same page in agreement as to what we do. So adding a party adds like 3. So it gets exponentially more difficult to resolve a multi-party case than just a one party, one defendant, one plaintiff, one defendant case. So once you understand that, then you know you need more lead time, you need more advanced prep, you need more advanced planning to get everybody in the boat. Second thing you can do to guarantee an impasse: ignore insurance coverage and assume everyone has investigated coverage competently. I can tell you stories and stories about that. So I'm an expert in insurance. I taught insurance for 25 years while I was a lawyer. So insurance to me is one of those things I think about all the time. It just comes naturally. But occasionally we will see people who come to mediation who didn't put the carrier on notice, didn't know there was coverage for that claim. And in the business world, in business litigation, this is a big problem. This is a big problem. Personal injury, not a problem. Everybody knows to go look for a policy. But in the business world, there are a whole number of torts in the business arena that are covered torts under coverage Part B of the CGL and under different kinds of policies like D&O policies. But oftentimes business litigators are not insurance nerds, so they don't know that there's coverage for those torts, and so they don't report claims. All right, it could be something like copyright infringement, covered; trade dress infringement, covered; invasion of privacy, right of publicity, covered; malicious prosecution, abusive process, constructive eviction. These are all business kind of related things. These are not personal injury claims. These are economic torts, economic injury, reputational injury, defamation's covered, right? So the whole slew of what I call business torts, non-personal injury type claims that are covered under coverage Part B or under CGL policies, under D&O policies. And they get underreported or they don't get reported, they get late reported. So not investigating insurance is a sure way to mess up a good chance for settlement. And then the other thing happens is people change their damage theories on the eve of mediation, or they join a new party, a few days before the mediation, and they expect a new defendant or third-party defendant to be up to speed and ready to mediate. No, that's just bad timing. Somebody wasn't thinking ahead. So adding a new person to the mix on the eve of mediation is not a good idea, because they're not going to have enough time to get their arms around the problem and make an intelligent settlement decision. So what you want to do is think real carefully about the timing of your mediation. Early enough so you don't have sunk costs, but not so late in the day that you got tons of sunk costs and tons of bad will and animosity, and you got yourself, $75,000 in fees on a case that has $100,000 settlement value. How many times do I see that, where somebody comes to me, they got $50,000 of fees in the case, and within the first hour or two, I know this case is going to settle for low six figures. It should settle for low six figures, but now I got a problem because I got the big blind's $50,000. And I don't know how I settle that case. It's pretty hard. It's pretty gosh darn hard. Okay, so one of the big things I preach and I talk about my engagement letter is sending a letter to the other side within the ambit of the mediation privilege, telling them, hey, here's how we see the case. Here's the things you need to think about. We really want to make a deal with you. Here's the impediments. Here's the issues that we see. Here's why I think making a deal for you makes sense. You're writing to them in ordinary folk language, not legalese, not case law. Don't tell them they're going to get summary judgment entered against them. No plaintiff believes they're going to get summary judgment entered against them. And first of all, plaintiffs don't know, most plaintiffs don't know what that means. And second, if they do know what it means, they don't believe it's going to happen. Right? They don't believe it's going to happen because their lawyer would have already told them. And if there is a high likelihood of summary judgment being granted against a plaintiff, well, they've already priced that into the settlement negotiations. I did a thing called the 10 Dirty Words. I wrote a piece called 10 Dirty Words in Mediation, using words like frivolous and sanctions and risk of attorney's fees. Is words you don't want to use in your position statements, words you don't want to use in your opening session for a variety of reasons. So the plaintiff, give everyone a reason to settle. Prep the mediation statement for the eyes of the opposing party, not the mediator. If you want to send me something different, you can, but don't ignore this opportunity to communicate directly with the other side unfiltered. You can say things in a letter you can never say. You won't otherwise have an opportunity to say. And then you can hark back on the themes that you introduced in your letter. You can revisit those things in your opening. Why should your opening be the revelation of new information? You want to set the table with the pre-mediation statement, and then you want to repeat and reiterate some of the themes and concepts that you made in your opening in your pre-mediation letter. You want to reintroduce those concepts and ideas in the opening, and then the mediator is going to use those same themes and concepts and ideas and bullet points in the private caucus in support of your position. You want to keep reiterating those same ideas until they sink in. It's pretty important. Preparing the client for mediation, boy, we could do an hour on that. Make sure you understand that. Tell them when you do your opening not to believe everything you say in your opening, because sometimes they get too emboldened. They think their case is really worth $2 million. It's not. You tell them the other side, the exposure is $2 million or more, but really it's probably more like 400,000 or 500,000. But you've got some clever damages argument, and your client believes it. Now you got a problem. Don't underestimate also the impact of the litigation on the client and the indirect costs, disruption of their business, maybe disruption of their vendor relationships, possible loss of employees. There's a level of stress and disruption. It's not trivial that often gets ignored by us. Don't talk about recovering attorney's fees because no one does. That's another myth. No one's going to get your fees paid. I mean, how many times do you ever get your fees paid in a mediation? Almost never. If there's some fee exposure, it gets priced into the settlement. All right. Use a verdict form with your client. If your client starts talking about their emotional upset and it's a business case, your emotional upset is not compensable. You show them what the verdict form looks like. Here are the line items. Yes, no. Here's the questions that they answer. Here's the damage items. That's all the jury's going to consider. I know it's a big, I know you missed your daughter's wedding, sitting for the deposition, whatever. I had to produce a bunch of documents and it disrupted your business and you had to work nights and weekends to do. Nobody cares. But they don't know that. So you have to remind them, this is the four corners of the litigation. This is what we're focusing on. You can't get all caught up in the heartburn and the hassle that the litigation caused you. That's not compensable. And then you use the position statement from the other side, assuming you got one. Use the position statement from the other side as sort of reality check for your client. So you don't have to be the one that tells your client the bad news. The other side's doing it for you in the position statement. I had a plaintiff's attorney tell me one time, he said, David, I can't thank you enough for the position statement because I needed to tell this client everything that was wrong with their case. And I didn't want to be the voice of bad news. See how you're doing yourself a favor by writing the letter? Isn't that clever? I didn't even know that when I was doing it, but then I thought thinking about it, I was like, yeah, it makes sense. He's using my letter for client control. Right. If I do a good job with the letter. Right. Now, if I say incendiary things in a letter, the lawyer's going to go, I don't think I want to show this letter to my client. But if you do the letter the right way and the right tone is so important, it's tone more than content. It's real important. You know, there's always common themes like it's expensive, it's time consuming, it's uncertain, there could be appeals. There's in any case, there's always 3 or 4 talk points you can always put in the letter, even if your case stinks. You can always give the plaintiff something to think about, right? Because you could. Somebody once told me, he said, David, doesn't matter how bad my case is, I always control the checkbook. That's right. That's right. If you're a defendant, you always control the checkbook. And that's not a bad thing. Another thing a plaintiff's attorney told me one time, which I remember, I think it was Dan Honeywell. I think that's who it was. There's a pretty well-regarded trial attorney here in Orlando. And Honeywell said to me, he said, David, you got to understand, time is the plaintiff's kryptonite. And I kind of always remembered that because I think it's true. I think that's a problem for plaintiffs generally. Okay. In the business context, you know, if your business clients, this is the thing that I figured out. I used to do a lot of IP litigation, and my clients were pretty smart, pretty entrepreneurial, interesting, you know, folks, and pretty smart, but they weren't necessarily business savvy, and they certainly weren't litigation savvy. They didn't know how to handicap a case. They didn't know anything about litigation exposure, risk. They didn't know how to assess the vagaries of litigation, but because they're experts in their field, because they may have been very successful in their field, they think that their business success, their business acumen, their intellectual prowess in one field translates over into litigation arena. And so they have supreme confidence in their position. So they've been confident about a lot of things and they've been right about a lot of things. But when you come to litigation, you're just an amateur handicapper. You're not, you don't know what you're talking about, right? So you got to be very careful not to let your clients' business acumen and hubris and success and sort of weight of the client make you take positions or make you think about the case in a different way or cause you to sort of step back and not be as forthright with the client as you want to be. Tell your client how bad the case is. They may not want to hear it, they may not want to accept it, but I've always felt way more comfortable telling the client the bad news than trying to shade it. I don't want to do that. Maybe they didn't want to hear it. Okay, too bad, so sad. I'm not gonna not tell you what's wrong with your case, and then have it blow up later on. I did legal malpractice defense too, so part of it was just self-preservation. If I tell you everything wrong with your case, you can't really fuss if it goes wrong. So I don't, and I never sugarcoated the budget either, because ESI can get expensive. If you get into some, you know, hot mess with your client's record keeping, it can get expensive. So I always understood that I want to make sure I had the true voice, and I want to make sure I gave them the straight scoop as I saw it. So sophisticated people and entities run the risk of being having more optimism bias than other folks. And so you got to sort of temper that. And the other thing you got to do is at the outset of the case, you got to tell them this case is probably going to settle. And again, they probably don't want to hear that, but that's the economic reality. That is the statistical reality. It's probably going to settle. So managing expectations becomes pretty important, particularly for the more sophisticated folks who are more likely to challenge you, more likely to push back, more likely to think their view of the world is the right view of the world, when really in the litigation arena, they're just rank amateurs in terms of assessing risk and exposure. We're all not very good guessers, by the way. We really don't have a crystal ball in terms of how juries are going to react. It's just we're a little bit more clairvoyant than our client, but we don't really have the powers of clairvoyance. We just have a benefit of experience. So managing expectations. I want to shift gears here for just a second and talk to you very quickly about covalence and TUMI agreements because they get frequently overlooked and they can be very powerful tools in business litigation. Business torts are frequently not reported to the carriers for the reasons we talked about before, or they're late reported. And if they are reported, it's not uncommon for the carrier to deny coverage and say, I'm not going to defend that lawsuit. So I've seen cases I've had, when I did, particularly in the IP arena, you'll see carriers that say, well, we don't cover that claim. Well, that's because coverage part B of the CGL has got some funky language, and it's not always clear whether or not the policy responds, and there can be difference in case law in the jurisdictions, and you can get into some kind of deep water. But if you get a denial of coverage and the carrier says, we're not going to defend that claim, and you think there's a possibility that the carrier is wrong, well, then you immediately have to be thinking about a covalence agreement, right? I guess I need to stick an L in there, got a typo. It's covalence, C-O-B-L-E-N-T-Z, covalence agreement. And that's what happens there is if the carrier does not defend, and they should have, you can make a deal with the plaintiff and say, okay, I'm going to confess to judgment for some number within the policy limit. I'm going to assign my rights against the insurance company to you, plaintiff, and plaintiff, you can sue the insurance company standing in my shoes and contend and argue there was a duty to defend. And if the carrier breached its duty to defend and should have defended and issued a wrongful denial, then the carrier is essentially on the hook for the settlement. One if the settlement was reasonable, not clearly excessive, then the carrier is on the hook because the law says if you jettison your insured and you leave them out to pasture with no protection, they can make any deal they think is reasonable to protect their own interests and assets. So almost any settlement within the policy limits is going to be a reasonable settlement. You get an expert witness to testify on your behalf. It says, hey, I made a reasonable settlement, and here's why. And so that's a covalence agreement. A TUMI agreement is like a covalence agreement, except a TUMI agreement occurs when there's negligence or malpractice by the insurance agent, and there's no coverage because the agent screwed up and didn't add the right endorsement or add an endorsement they should have, or took away coverage via an exclusion that shouldn't have been on the policy, or forgot to add a company as additional insured. There could be a number of ways insurance agents screw up. And if they screw up, that's called an errors and omissions claim. And errors and omissions claims against agents are well recognized. There's a whole body of law on that. And if the agent screwed up and you can prove there's some negligence on behalf of the agent, failure to advise, failure to warn, failure to procure, whatever it might be, that is called you have an errors and omissions claim, and you can assign that claim, just like under covalence, you can assign that claim against the insurance agent to the plaintiff's attorney. And the plaintiff's attorney, standing in the shoes of the insured, can sue the insurance agent for the agent's negligence. So you can say, well, okay, but for the agent's negligence, we would have had all this coverage, but the agent screwed up. So we lost the benefit of coverage. And so now my hotel doesn't have any coverage for this personal injury claim or whatever kind of claim it is, business tort, trademark dispute, whatever it is. The agent screwed up and put an exclusion on the policy that shouldn't be there. And if you can prove negligence by the agent or breach of fiduciary duty by the agent, you can get a judgment against the agent, and the proceeds of that judgment get assigned to the plaintiff's attorney. And the defendant in these cases can then get out of the liability by essentially giving the plaintiff a second cause of action against either the insurance company, which we call a covalence agreement, or a cause of action against the insurance agent for the insured defendant. And that cause of action, if assigned, is called a TUMI agreement. The defendant gets a covenant not to execute. And so they're insulated from potential liability by assigning their rights either against the insurance company or against the agent to the plaintiff. That's a very common, it's a very useful tool. It doesn't happen very often, but when that opportunity presents itself, if you're a business litigator, you need to know that. You need to know that there are going to be times when you tender the defense, the carrier says no, and then you sort of got the carrier over a barrel because if they got it wrong, they could be in real big trouble and end up paying a huge judgment because they got it wrong. And there's a whole body of law on that. Covalence has been around for a long time. So it's real important that you understand coverage part B of the CGL and insurance coverage that could potentially apply to business torts, like the ones we talked about: copyright, trademark, invasion of privacy, constructive eviction in a real estate arena, malicious prosecution, abuse of process. Some of the business torts here, sometimes you'll see coverage for you'll even see coverage sometimes for breach of fiduciary duty under D&O policies. Even D&O policies sometimes will have coverage defense for criminal acts up until the time of the adjudicated criminal activity. For fraud covered under a D&O policy, not indemnity, but defense. So there's a variety of different policies that might apply in the commercial context. You need to be mindful of. If you don't have expertise in insurance as it relates to business torts, you can go find somebody who does. Opening statement in mediation. Boy, we could do an hour on this too. Who are you talking to? Know who's in the room. Be prepared to pivot. I always used to have an opening kind of prepared in my head, but based on how I read the room, what the temperature in the room was, based on what people said, sometimes I would pivot. I wouldn't do the statement that I thought I was going to give. So it's a lot like OA on appeal sometimes. You got your issues on appeal, but sometimes you get pulled in a different direction. So be mindful, sort of read the room. That's really important. Saying the right tone is important. Knowing what you want to say, but being flexible enough to know that maybe what you had planned to say isn't going to work. Are you trying to humanize your client? Are you trying to reduce tension? Are you trying to create optimism? Are you calling them a malinger and a liar and a fraud? And if so, why are you doing that? I can't understand defense lawyers that beat up on the plaintiff in the opening session. I never understood that. I never understood. I had a plaintiff's lawyer tell me one time, I was the mediator, and he said, David, I want you to go tell the defense lawyer how much I appreciate him not beating up on my client, because there was a lot there. There's a lot there. And he goes, I want to please thank the defense lawyer for the way that they did the opening session, because I thought I was going to have to pull my client off the ceiling. And he was very respectful during the opening session. It makes it so much easier for me to settle the case. You see how this works? You start thinking in those terms, you sort of get it, right? You sort of get it. But some lawyers can't help themselves. They feel the need to saber rattle vigorously. And sometimes your client wants to hear that. So you tell them, you say, I'm not going to saber rattle, and here's why. I know you want me to say this, this, and this, and this. And I know that this has made you upset. And I know this has made you angry. I know you think the guy on the other side or the lady on the other side is a complete tool and an awful human being. I'm not going to say any of those things in this opening because that doesn't help us get the case resolved. So have that conversation with your client ahead of time. If you're going to speak in a certain way that the client wouldn't necessarily anticipate, tell them in advance what you're doing and why you're doing it, so it doesn't come as a shock to them. It doesn't get them upset and view you somehow as, not being the advocate of their cause. It's not opening statement for trial purposes. It's opening statement for mediation purposes. It's not the same opening statement. It's not. Maybe we shouldn't even call it opening statement. Maybe we should just call it a conversation, opening conversation, because opening statement sounds like a trial presentation. It's not. You're not trying to convince me or some third parties to make a deal. You're trying to convince the opposing side to make a deal. You're not looking for votes. You're not trying to score points. It's not a point scoring opportunity. It's setting a table for a deal down the road. So that's pretty gosh darn important. Okay, we've got about 10 minutes left. If we run out of time, we don't get a chance to do questions, and we may not get a chance to do questions. I'm going to probably, if I can't get to your questions or your comments, you can either call me or you can email me, and I'll be sure to respond. And this is true if you see this video weeks or months down the road, assuming I'm not pushing up daisies. But I really want to encourage you to reach out to me if you need questions and things. I get questions all the time, sometimes from other mediators. I had one the other day, somebody in the middle of the mediation, he said, I got this going on, what do I do? I'm happy to take that call. It's fun for me. I like trying to troubleshooting if I get a chance to do it, and, get somebody out of hot water, or avoid going into hot water, doing something that's going to create a problem for you. So don't hesitate to give me a call. Okay, so a couple things working with the mediator. Be mindful there could be some non-economic terms. We usually put those at the end of the day. Use the mediator to brainstorm for non-obvious paths to resolution. Don't assume that sometimes in mediation, the best solution is the one you just think of the day of the mediation. It's one of the organic benefits of the mediation process is that you put a bunch of smart people in the room, you start noodling on one problem for 4 or 5 hours, and somebody comes up with an idea we hadn't even thought of before. Happens all the time. Happens all the time. That's one of the cool benefits of mediation is that we got a bunch of smart people noodling on one problem. In the real world, we don't get to do that very much because your timesheet's got 6 different files open on a single day, and you're going all different directions. So mediation is kind of cool in the sense that we get to focus on one problem. That's why it sort of works, because we are focusing on one problem. So if you have some subject matter expertise with your mediator, that's helpful because you can sometimes come up with a deal that other people wouldn't think of. So if I get hired for a trademark case, I'm pretty excited about it because I did trademark work. So I can usually come up with at least some ideas or some suggested language, or if it's a deceptive unfair trade practice, something that's in my wheelhouse. Yeah, I'm pretty happy to be doing that kind of case. And I think I can add some value if it's in my wheelhouse. So I look for a little subject matter expertise. That's one of the great things about having a crazy career path. If you do a bunch of different stuff, it kind of inures to your benefit later on when you're doing mediation. I got to talk about this. If I don't talk about this and this call ends before I talk about this, I'm gonna be unhappy. So I got to talk about this. There is a real problem in the mediation rules as it relates to enforcement. Rule 1.730, it's C, it's now D because they just changed it, but it's 1.730D says, in the event of a breach of a mediated settlement agreement, the court may impose sanctions, including costs, attorney's fees, and other appropriate remedies, including entry of judgment on the agreement. Okay, blah, blah, blah. That's just a basic rule. It says I can file a motion for sanctions under 1.730D. Right. It used to be C, now it's D. Okay, so if somebody breaches a mediated settlement agreement, fails to pay, or fails to do something under the settlement agreement, you just file a motion under Rule 1.730D, and you say, I'm filing a motion for enforcement, motion for breach, whatever you want to call it. Not so fast. The case law is unambiguously clear. The case law from the Florida Supreme Court and from intermediate DCA says, if you have a breach of a settlement agreement, the trial court doesn't have jurisdiction over that breach, over that claim of breach, merely because it had jurisdiction over the underlying claim that gave rise to the settlement. So it's a jurisdictional problem. The court doesn't have jurisdiction over that dispute, over those parties. You got to file something else. What do you got to file? You got to file pleading. So you got to file a supplemental complaint, right, under the supplemental pleading rule, or you got to file a separate action, depending on, where the underlying case is and where the breach occurred, et cetera, et cetera. You got to prove your breach of contract. It's a breach of contract claim. And so the Supreme Court says that's what you got to do is you got to get jurisdiction over the parties to enforce the contract. You got to plead a cause of action. Right, makes sense. So the rule is overbroad. It makes you think you can bring certain claims for breach by rule when you can't. You got to do it by pleading. So well, what is Rule 1.730D supposed to cover? It would cover things like if you sanctions related to what I call process problems, failure to attend, inadequate authority. Someone didn't file a certificate of authority that they were supposed to file in state court. So things like, or if you have an agreement that has been filed and approved by the court, if you have an order approving a settlement agreement, and there's a breach of the terms of the settlement agreement, which has been incorporated into a court order, then you can use 1.730D because the court has the inherent authority to enforce its own orders. And so if the agreement's been approved by an order of the court and adopted essentially into the record, so to speak, then you can file a motion under Rule 1.730 to enforce the settlement agreement / order, right? Because it's been filed with the court. The rule is kind of funky because it was created back like 30 or 40 years ago when it was more common to file settlement agreements with the court or have the court approve the settlement. We don't do that anymore. We do that very rarely. Unless it's like an employment context where you have to approve a FLSA settlement or something like that. We don't get court approval of settlements. We just settle the case and we file stip for dismissal. But in the old days, it was much more common to file the agreement and have the order have the court approve the settlement for whatever reason. And so this rule is kind of a legacy of that, because Rule 1.730D contemplates that the agreement's already been filed and approved with the court. It doesn't say that in the rule, and you wouldn't know that from the rule. You'd only know that by the case law that says unless it's been approved by the court, you can't use one unless the agreement's been approved by the court in a court order, you can't use 1.730D to enforce a breach of a mediated settlement agreement. It's a separate claim for breach of contract. Now, I will tell you to a moral certainty that nobody knows this. Very few people know this rule and know this case law, because I've seen it come up a dozen times where I've seen somebody file a motion to enforce a settlement agreement, and even the trial court didn't know this case law, and the trial court entertained the motion. They're not supposed to. So if you're defending a claim for breach of a mediated settlement agreement and someone files a motion against you, you need to jump to this case law and say, no, you got to file a pleading. And you want them to file a pleading because then you can plead your defenses. You may have like no contract information, no contract formation. We didn't make an agreement. We didn't reach a mediated settlement agreement. All we have here is a term sheet. We didn't execute the final documents, or whatever your contract offenses might be. You want to be able to plead. How do you plead in opposition to a motion? You can't. That's the problem. So the case law makes sense, because if you have a claim for breach of contract, you got to bring it in a pleading. Right. Makes a lot of sense. Okay. Confidentiality rules and mediations conducted out of state. We just got a couple of minutes remaining. Just be careful when you go out of state. In business torts, you're more likely to be traveling out of state. The rules of engagement can be very different. The confidentiality rules can be different. They could have some funky good faith requirements. There's no good faith requirement in mediation in Florida. I know there's federal case management orders that say that. It doesn't really exist. It's not enforceable. Mediators can't report bad faith or good faith in Florida. Certified mediators can't do that. So, but you go out of state, weird things can happen. Rules are engaged and are different. So just be mindful of that. Always be mindful of the fact that there's a business solution to the problem. You're going to probably settle this case. You're probably going to settle this case. It may not happen right away, but get the client to understand. And if there's something else I can give you besides money, look for non-economic things you can give them. Look for things that, I've had parties that split apart and put them back together again. They had a breach of contract, or they had some deal gone bad, and I put them back into the deal, or I gave them some other business opportunity they could work on together. I put training wheels back on their relationship. Sometimes there's clever solutions to the problem. If we have more time, I talk about an NDR proceeding. NDR proceeding is a use of a neutral that essentially acts as a little mini arbiter and decides the case based on for a fixed fee. There's more on NDR on my website. If you have more questions about what an NDR proceeding is, it's a neutral driven dispute resolution. It's a new thing, got started in California a couple of years ago. It's for low cost commercial disputes where the amount of controversy is under $200,000, and the process essentially revolves around a neutral being the fact finder, doing the discovery, doing the witness interviews, reviewing the documents, and ultimately issuing an opinion. So it's like a very informal arbitration. The point of it is to reduce the amount of lawyer costs, legal spend, and get a much more quick result and final result. That's what an NDR is. Okay. Key swing thoughts for business litigators. How's this going to end? Have we considered appellate review? Have we considered a possibility that things might go horribly wrong? And if so, someone's going to have to appeal. In business disputes, particularly, there's a much greater risk of an appeal. And so you need to be mindful of that when you're assessing the viability of a settlement, the advantages of the settlement. I have these cases and I go, this case is untriable. You guys got so many legal issues that someone's going to get, the court's going to have to rule on. Someone's going to feel like they got it wrong, and you're going to have a high degree of appellate risk. Well, if you have a high degree of appellate risk, your client needs to know that, right? And trial is not going to be the end of the day. There's too many issues out there, too many strange and either factual or legal issues out there. And so you have to be mindful of that when you're counseling your client on whether they should take that deal or not. I always think about appellate risk. Some cases don't have a lot of appellate risk, but some cases, particularly business disputes, like IP cases in particular, oh my gosh, the rate of appeal on IP cases is really high. And the rate of reversal on IP cases is higher than the regular rates of reversal. So when you're in an IP case, trial is just the start. I know that from personal experience. I got a couple bad cases out there against me. So I know that to be true. Okay, so that's just about wrapped it up. One thing quickly about term sheets. So if you can't get the deal terms done, you can't get the final settlement paperwork done, which is frequently the case when we do these complicated business disputes, Do you have a term sheet? Just make sure when you walk out of there that you know that the term sheet's not the final deal and everybody understands it's not an enforceable settlement document. There's more documents to be done. Don't walk out of mediation unless you're very clear on whether this is the final settlement document or this is just a term sheet and a memorialization of terms. That's pretty gosh darn important. I think it's sort of mediation malpractice if I let you walk out the door and you don't know whether this is a final deal or whether there's something more to come. So that's a little bit of a crash course in business litigation, mediations, and being a problem solver. So the idea is when the client comes to you, you don't view trial as the thing that's going to happen. You view resolving the problem as the thing that needs to happen. Trial is just sort of a last resort. We're going to look at some other ways of resolving this problem, mediation being the most obvious one, maybe an NDR proceeding, maybe an arbitration, but we're going to look at other ways of resolving this dispute. And being the problem solver and being a good mediation advocate should be part of your marketing, right? Because the clients don't want to hear you're a great trial lawyer. That's like being a chef. Like I liken being a great trial lawyer to being like a chef that makes these really amazing dishes, but nobody orders them. They don't order them. they don't order them. You're ordering something that only 1% of the consuming public eats, right? You're making a dish that only 1% of the public eats. That's not being a very good chef. You got to feed the thing that people do is mediation, and they want their case resolved in mediation. So touting yourself as a good mediation advocate, I know it doesn't sound sexy, but touting yourself as a good mediation advocate makes a whole lot of sense from a business development standpoint, because that's what the client wants to hear. I can solve your problem. I can get you to a solution that makes sense without 2 years of litigation and $250,000 invested. That's the message that sings. So I commend those lawyers and law firms that are making ADR and making mediation part of their language on their website and their marketing materials. That's what clients want to hear. They don't want to hear you're a great trial lawyer. That's a big money expense. They want, yeah, you got to have that skill. What they really want to know is, can you solve this problem for me? And having the kind of personality and skill sets and intellectual creativity that gets them to a deal sooner rather than later, that to me is sticky in the Malcolm Gladwellian sense of the word. It's sticky. That's the sort of thing that should attract and keep business and keep your competitors at bay. You have the perception of being, oh, this Henry guy is a problem solver. This guy, he's a little quirky weird, but he solves these problems for me and he gets me out of these jams. That's what I'm looking for. That's my whole take. That's why I did this seminar. That's sort of what I'm passionate about, is getting clients out of these jams sooner rather than later. And if you can do that, I think you're going to get referrals and I think you're going to get business. So that's about it. If you have any questions, comments, if you want to read more, my website, I've got blog pieces. I've got a monthly blog that goes out you can sign up for. I've got a really good, what is a mediation letter, that's on my website under resources that you can use. I sort of a one size fits most, and you send that letter out to your client, a couple weeks before mediation or more, answers all the questions about mediation. I tried to draft it so it's one size fits most. So just about any kind of client can read that and save you a lot of time, and also kind of educate your client on the mediation process. So that, what is a mediation letter, a mediation memo to client, very useful. And then my checklist is also on the website, and that could be very helpful in sort of creating a chronology of events that you want to use. Now I've gone over. I apologize for going over a little bit. If you have any other questions or comments, please reach out to me. Thanks very much. I enjoyed it. Take care. Oh, of course. Hold on. Let me look. Hold on. Yes. Mm.